Welcome to the Mediabox. Titus Corlățean here to talk about the legal aspects of the accession of the European Union to the European Convention on Human Rights. First of all, where are we at? What does the Assembly decided today?
So after more than 40 years from the moment when the process of negotiation started, or it was inspired to start, we are finally quite close. Not yet there, but quite close, because a revised protocol for the accession of EU to the European Convention of Human Rights was finalized. And it received, let's say, a positive push last year in September 10 through a decision of the European Court from Luxembourg on a already famous EU Lex Kosovo case that made some clear separations as concerned the hot topic of foreign affairs and security common policy. And this became a good avenue for finding a compromise solution among some EU member states that asked that the treaties of the European Union to be respected as concerns this policy. And on the other side, to advance towards the final solution for the EU accession. We still wait, and I understood as a rapporteur of the Parliamentary Assembly that the European Commission is preparing a procedure and for asking a final opinion. I hope this time to be a positive one from the judges from Luxembourg. And having the positive opinion, the next steps will be technical, mainly technical. So we can envisage that maybe 2 years from now, 2.5 years from now, we can deliver a historical goal to be fulfilled, EU accession to our convention and to our court in Strasbourg.
As you said, it's been a long and complicated process. If it does, as you hope, happen, what would the impact be?
Well, we can understand better if you think, and we think, to the serious challenges currently on our most democratic European continent against fundamental human rights, a continent that knows or tried to survive to the horrible suffering coming from a war of aggression from Russia against Ukraine with all the consequences. So this is why it's not a need, it's a must to assure a common European space, a cohesive space for the protection of fundamental human rights, to avoid application, because we have two courts of justice, one is in Strasbourg, the other one is in Luxembourg, to avoid possible contradictory jurisprudence solutions between those two courts. So to assure also that the EU citizens, which are also members of the Council of Europe states, can address possible violations not only against their own states, which are members of the Council of Europe and also members of the European Union, but also against EU and the EU institutions. This is something that is missing right now. And once again, it will be a historical goal that will be achieved.
Titus Corlățean, thanks for joining us.
Thank you so much.